Okay, we're going to take a look at question 4 from 2007 July. It's criminal law / constitutional law, just a small little constitutional law issue. And the only reason I'm mixing this in is because it is so very rare for the examiners on California law, California bar exam, to actually test criminal law by itself. It's usually crossed over with criminal procedure, and here is actually uniquely crossed over with constitutional law. Now, the way that I go through an essay here, and before you watch this video, it is highly recommended that you read the fact pattern 3 or 4 times. Just read it, understand it, look at the call to question, and the way that we're going to do it right now, the way that I'm going to do it, is exactly the way that I would like you to do it on the bar exam. You know, make sure you read the fact pattern. Getting familiar with the fact pattern and understanding exactly what the examiners are asking is so imperative. So many people, and you want to know why the passage rate's where it is, people will read this question one time and just start jamming on the keyboards. A lot of people in the room will get nervous and go, oh my God, that person sitting next to me who's already started to type within the first minute and a half is so smart. No, they're the people that are failing because they haven't had any time to process it. Do me a favor, if you see someone starting to type within the first minute or two, hand them my card, they're gonna need it. Those are the people that are gonna be taking the next bar exam. So you should actually be happy when you hear that, just go, that person's an idiot. All right, because you actually have to think about it, you have to understand, you have to read it, and you have to process it, and only then can you analyze it, and after you analyze it, can you write about it. Okay, one thing I like to do, you always have to go to the call to question first, because it'll tell you what you're being asked and what you need to look for. Don't forget, California bar and the California bar exam, they give you the issues a lot of the time. I mean, a tremendous amount of time, the examiners will actually tell you the specific issue they want you to discuss. So if you actually read it carefully and pay attention to what they're asking, there is no really, very few subjects are issue spotting. Evidence and PR are issue spotting. We'll get into that later. But for this, criminal law, they almost give you the issue every single time. It says, hey, may Dan properly be found guilty of the crime of murder or any lesser included offenses? So, okay, well, what's the lesser included offense of murder? You got voluntary manslaughter, you got involuntary manslaughter. There you go. So you're probably going to have to discuss each one of those in this essay. Why? Because the call to question is asking you to do so. All right, call number 2. It said, how should the court rule on each ground of Dan's motions to dismiss the charge of attempting to burn the U.S. Constitution? Notice it says, how should the court rule on each ground? Guess what? The examiners must tell you the grounds that he's challenging. So many people just somehow don't catch that. So call the question for number 2 is actually in the paragraph right before that. So whenever you see, especially happens in constitutional law, criminal procedure, and civil procedure, if they're arguing a specific motion, look at what the motion to this is. So let's go to the paragraph above, because you'll find the motions usually in the paragraph right above the call to question, as that turns out to be part of the call to question. In fact, if you notice something too, this fact pattern is incredibly short. It's only really 3 paragraphs. I mean, it's 2 paragraphs and 2 little short sentences. And the rest of it is just a call to question. They're specifically laying out what they want you to discuss. So pay attention to it. This is why reading carefully and answering the call to question are so ultra important. Okay, for call number 2. We'll put that over here. How should the court rule each analysis? Dan was arrested and charged. So formal charges attached. 6th Amendment right to counsel applies, and all your 6th Amendment trial rights apply right there. Of course, I'm not asking about it here. I'm just thinking out loud, just to get you always thinking about analyzing facts and what the examiners are trying to say. Charged with the crimes of murder and attempting to burn a copy of the U.S. Constitution. So he's being charged with murder and attempt of a different crime. He has moved to dismiss. That is the motion to dismiss right there. They're giving you these grounds that the motion is based on. He's moved to dismiss the charge of attempting to burn a copy of the U.S. Constitution, claiming that, number 1, and this is it. So it's 2 part 1. They said each ground. What he burned was actually a copy of the Declaration of Independence. So what Dan is essentially saying, and this is why you need to read it and comprehend it and really understand it. He's saying, I should not be found guilty of attempt because I was actually burning a copy of the Declaration of Independence, not a copy of the U.S. Constitution. All right, so obviously the issue is attempt and whether or not what he did falls under that. And it says, number 2, the state statute on which the charge is based violates his rights under the First Amendment to the United States Constitution. Now, obviously, this is the part that's constitutional law. And this is First Amendment. All right, cool. As a tip, when the examiners ask more than 2 calls of the question, here we got really 3, they do not backload it, they front load it. What I mean by that is, out of all these calls of the question, this is a general rule, it's not going to apply in every single essay, but it's going to apply in about 95% of them. So don't tell me the one that was, oh, well, they didn't do it here. Yes, I know they don't do it every single time, but it's something to realize. And why I'm pointing that out, what I mean, the examiners are going to front load it. So this is likely to be the most important call of the question. Now, this is going to be the least important call of the question. As a rule of thumb, that is true. Now, why am I telling you that? Because I don't want you to rush to finish. Take your time and spend the first 45 minutes doing the best you can. Spend the last 10 to 15 minutes wrapping it up. And if you only have 15 minutes to answer these 2 calls, that's fine. But don't spend only, if you think you're going to spend a half hour here, you're wrong. 5 to 10 minutes, and believe it or not, call 2 is sufficient. You'll see what I mean. Okay, and that's usually as a rule of thumb. Let's take it from the top. Dan stood on the steps of the state capitol and yelled to a half a dozen people entering the front doors. Stop right there. And this is what we're doing. We're stopping at every commas, periods, quotation marks, numbers, dates. Pay close attention to those. The examiners are putting them in there for a reason. So here, and specific language, when they use descriptive language, it is so important to pay attention to descriptive language. A half a dozen people. Why is that important? I mean, there are literally 6 people sitting here to him. Is he trying to incite a riot? Does he have a big group together? I don't know if you've ever seen the black and white videos of Nazi, Germany in the 40s. When Hitler was trying to incite the riot, I mean, there were thousands and thousands of soldiers lined up listening to him. That is completely different than what's going on here. So understand the stark contrast between the two. It's not inciting a riot, it's not imminent lawless action or anything like that, because we do have a First Amendment issue that we're going to have to discuss. So he's on the state capitol building and yelled to a half dozen people entering the front doors. Listen, citizens, so he's exercising his First Amendment right to free speech. That's going to show up when we talk about devoid of social utility for depraved heart murder. Listen, citizens, prayers in the school means government-endorsed religion. State church, they can take away your constitutional rights just as fast as I can destroy a copy of the U.S. Constitution. All right, so he just has a problem with church and state. He wants the government and religion to stay differently, and he doesn't want religion to be in schools. He's just exercising his First Amendment right, trying to make a point, state capitol building, and really no one's listening to him. That's essentially what's going on in the first paragraph. And don't forget, he's also believed that he's going to destroy a copy of the U.S. Constitution. Keep that in mind because it goes to the attempt. And that's why we read this thing multiple times so you can put all these together. And I assume you've already read it multiple times, you already kind of know what's going to happen. With that, Dan took out a cigarette lighter from his pocket and ignited a parchment document, which is a type of paper, that he held in his left hand. Okay, the document burst into flames. And when the heat of the fire burned his hand, he involuntarily let it go. Now don't forget, with criminal law, we've all thought bad thoughts. I want to kill that person. But you don't act on it. And we've all done things that have been completely unintentional. Let's say you swing your arm out and you hit someone. You didn't intend to hit them, so you're not going to be found guilty of the crime of battery because the intent's not there. It wasn't substantially certain. You didn't act with the purpose of hitting them. So that would more be a negligent act. So don't forget, you need act and intent for criminal law. And we want to criminal law is about this. We want to punish somebody for having a bad intent and acting on it. So any kind of crime requires act plus intent. Strict liability crimes only require act. Okay, so he involuntarily let it go. So the question is, did Dan actually act? was it a voluntary action? It has to be voluntary, not involuntary, like spasms or seizures, something like that. The answer is, believe it or not, yes. Even though it says he involuntarily let it go, he actually set in motion the chain of events that caused this. So by lighting the document in his hand and burning it, it actually was a voluntary act. Again, it wasn't that he was forced. It wasn't that he was having an epileptic seizure or something like that. This was actually a voluntary act. So voluntary, and you have to discuss the voluntariness of his actions. The question is, well, where do I put that? Do I put that here, there, where? The answer is it doesn't matter. When people say they have trouble organizing an essay, I have no idea, first of all, idea what that means, because it doesn't matter how you organize it. The examiners aren't looking at whether or not it's organized in a perfect manner. So you could have voluntary in the beginning, you could have it at the end, you can have it anywhere you like, as long as you discuss it and articulate it in an intelligent manner. What the examiners are actually looking for the essays is, did you apply the law correctly to the facts? Yes or no? It's not how much law you memorize, it's not how many issues you can put in there. I mean, do you think they want to hear anything about any other issue except for murder? No. They want to only hear about what it falls within the realm of the law of murder. Okay, so a wind blew the burning document into a construction site where it settled in an open drum of flammable liquid. It exploded, carrying a nearby pedestrian. Did you see that coming? I mean, when you first read this, did you see that as being a possible consequence of lighting this document on fire? And if you're sitting there shaking your head, oh yeah, I saw that coming, I would like to know who you'd like to win for the next Super Bowl, because there's no possible way you could have predicted that. It was such an unforeseeable event that it was very strange and bizarre. That's proximate cause, is whether or not something is foreseeable. And think about it. He lights the paper. Then it burns his hand. A wind blows it. And while it's still burning, the wind's blowing it into a construction site. Realize we're at the Capitol building, so I have no idea where this construction site is, but it's got to be pretty far away. You still have this burning document going down the street. Nobody's stomping out. It's blowing, but it's still burning. And then it goes into an open drum of flammable liquid. How many open drums of flammable liquid do you walk by on a daily basis? I've never seen one. And this burning document somehow finds its way in there, it explodes, and it just happens to kill somebody walking by. Now do you see how ridiculous that fact pattern sounds? And that's because the examiners are getting at foreseeability, which is part of causation. And you'll see where that's going to fall in a second, because we're going to go through the murder analysis, but I'm just saying voluntary and foreseeability. This is how you quote-unquote, if you want to say, spot the issues or find the hidden things that are going on. And that's just by reading the fact pattern carefully to understand what the examiners are getting at. Okay. A state statute makes it a misdemeanor to burn or mutilate a copy of the U.S. Constitution. And that's what he said. I'm going to destroy a copy of this U.S. Constitution. And because it's a misdemeanor, misdemeanor manslaughter. I could see them getting at that. And you'll see how the involuntary manslaughter turns out to be a bulk of what this question's asking. It turned out that the document he had burned was actually a copy of the Declaration of Independence, not of the U.S. Constitution, as he believed. You know, it's interesting, that phrase, he believed, that is such a repetitive statement when it comes to the criminal law. Notice in criminal law MBEs and criminal law essays, they will tell you what the defendant believed. Why? Because they have to give you his intent. In real life, the prosecution's not going to know what the defendant intended, and that's why it's going to be hard to prove the crime. But generally intent's proved from circumstances and inference and whatnot. But in the examiners, they have to tell you what the defendant believed to show you what the defendant's intent is. Okay. Now, number one, may Dan properly be found guilty of the crime of murder. So understand, let's go to the definition of what murder is. Murder is the unlawful killing with malice of forethought. That's it. That is the definition of murder. Now, it's the unlawful killing. Obviously, it's unlawful. If it was lawful, it wouldn't be murder. Unlawful killing with malice of forethought. That is it. All right. Make it simple, because a lot of people will start getting confused with degrees and what the elements of malice. Just stop right there. All murder is an unlawful killing with malice aforethought. Now, malice aforethought is the intent for murder. That's all it is. And you can prove the intent to commit murder in one of four ways. Intent to kill, great bodily injury, depraved heart, and of course, the felony murder rule. All right, let's discuss each one of those because did Dan, the defendant here, have the intent? Did he have malice? Did he act with malice aforethought? Obviously, we have a voluntary act. Essentially, all we're trying to do is this: acting intent. Was the act voluntary? Yes, because he set in motion the chain of events. Now, did he have the intent? Did he have the intent to kill? No, clearly he didn't intend to kill anyone. He wasn't using a deadly weapon. All he intended to do was exercise his First Amendment rights, and he had no idea what was going to happen. Intent to kill, easy. Intent to cause great bodily injury? He didn't want to harm anyone. Next. Depraved heart. Did he act extremely reckless? And sometimes the definition of depraved heart murder is defined as an extremely reckless act that is devoid of social utility. And what I mean by devoid of social utility means it lacks any usefulness in society. So ask yourself, what is Dan doing? Well, he's exercising his First Amendment rights. Is that something that's useful in this society? Absolutely. Think about this. He's exercising his First Amendment rights on the state capitol building, protesting church and state. We have people who are firing guns into a crowded building, driving cars at 85 miles an hour in a 15-mile-an-hour zone. Is that have any usefulness in society? No. That's why that's an extremely reckless act, and here it's not an extremely reckless act. So, no depraved heart murder. Well, is he committing a felony? No, he's not raping anyone. He's not committing burglary or robbery. Arson, he's not trying to burn a dwelling. Clearly there's no arson. Again, arson requires recklessness or intent, and we already talked about recklessness here, so no arson. Obviously, it's not going to be murder. Okay, so next, voluntary manslaughter. Did he act under heat of passion? No. And also, voluntary manslaughter is an intentional killing. So you obviously have to have the intent to kill for voluntary manslaughter. No, he didn't intentionally kill anyone. He didn't kill them under heat of passion. That's what voluntary manslaughter is. So no voluntary manslaughter. Almost a non-issue. Bring it up, shoot it down really quick. Don't spend forever on it. Now, involuntary manslaughter. Okay, now we're talking. Involuntary manslaughter has two parts. One is criminal negligence. All right. Part two is misdemeanor manslaughter. And my spelling up here is going to be abbreviated and whatever. And misdemeanor manslaughter can be one of two things. It can be malum prohibitum or malum in se. We're getting this on the board right here. Are they able to see this? Okay. So let's talk about criminal negligence. What is criminal negligence? You know, it's the lack of duty of care. It's a little bit of a higher degree of failure to exercise reasonable care. You generally have to be aware of what you're doing, but it doesn't have to rise to the level of a depraved heart murder, which is extreme recklessness. This is negligence and extreme recklessness. It's the same thing. This is just the older brother of this. And felony murder rule is the big brother of misdemeanor manslaughter. It's kind of interesting. So take misdemeanor. If someone dies in a misdemeanor, someone dies in a felony. Someone dies by negligence, someone dies by recklessness. You see how they're just the big brother, little brother of each one? It's actually kind of cool to think about. And again, this is an unintentional killing. It's involuntary. If it was an intentional killing, we'd have one of these two. So let's talk about criminal negligence. And as you know, in torts, there's the intent and there's negligence. Same thing here, intent and negligence. So very much parallels itself. All right, criminal negligence. What did he do? What did Dan do? Did he act negligently? First of all, you could say that his act was a little bit careless, but where this thing falls apart is was what he did foreseeable? Because negligence requires causation. Clearly, Dan was the but-for cause. I mean, but for him lighting the document, the person wouldn't have died. But was it foreseeable? This is the issue of proximate cause. And I think that it's too tenuous. There's no way that Dan could have realized this. I don't think a reasonable person could have realized that exercising your First Amendment rights and burning what you believe to be a copy of the U.S. Constitution would cause someone to die. I don't think that that's a foreseeable result of it. So no proximate cause. So it's probably not going to be criminal negligence. Let's talk about misdemeanor manslaughter. Malum in se and malum prohibitum. Malum in se is an act that's inherently evil, like battery. That's the classic example of malum in se, battery. Well, he didn't commit a battery, and this is only prohibited by statute. That's what malum prohibitum is, because the misdemeanor is burning a copy of the U.S. Constitution. So because it's not malum in se, the question is it malum prohibitum? Is it prohibited by statute? It is. So it's a misdemeanor to burn a copy of the U.S. Constitution. However, he will not be found guilty of murder under involuntary or misdemeanor manslaughter for malum prohibitum, because death has to be foreseeable based on the statute. By burning a copy of the U.S. Constitution, it is not foreseeable that someone's going to die. So there's no causal connection, no foreseeability. It's not malum prohibitum. The second thing is, what we're later going to find out is, because the statute's actually suppressing speech, and the whole purpose behind the statute is to prevent a certain type of expression, it's going to be an unconstitutional statute, so you're not going to be able to find him guilty under malum prohibitum. So, the answer to question 1 is, may Dan properly be found guilty of the crime of murder or any lesser included offense? In one word, no. It's just a freak accident. Now, he might be civilly liable, just like OJ was, but not criminally liable. Okay, second part, attempt. Now, attempt is a specific intent crime, which means you have to have the underlying intent. You have to have the underlying intent no matter what type of crime it is. Let's see, the best way that I saw it phrased was, regardless of the underlying crime, attempt is always a specific intent crime. Okay, so what he believed he was burning was a copy of the U.S. Constitution, but he was actually burning a copy of the Declaration of Independence. So this has to do with mistake of fact or factual impossibility. Now, factual impossibility is not a defense to attempt. Now, of course, he can't be actually convicted of the actual crime of burning a copy of the U.S. Constitution because he didn't actually do so, but he could be found guilty of attempting to burn it. Let me explain it in a way that you'll definitely understand this. Let's say that I break into your house one night, you're sleeping in bed, and I shoot you 3 times. Any one of the shots would have killed you. An autopsy report turns out that you had died a half hour before I broke into your house and shot you. You had died of a natural causes for a heart attack or whatever. You died in your sleep. So I can't be found guilty. I can't be convicted of murdering you because I did not cause your death. You were already dead. But because I believed that you were alive, and I believed that I was actually killing you, I can be found guilty of attempted murder. So mistake of fact or factual impossibility is not a defense to that. That's what's going on here. He believed he was burning a copy of the U.S. Constitution, and because his belief, he had the intent to burn a copy of the U.S. Constitution, because that's illegal, factual impossibility will not be a defense. Still, he will not be found guilty of attempt, only because the statute is later to be found unconstitutional. But assuming the statute was constitutional, he could be found guilty of attempting to burn a copy of the U.S. Constitution. And the last part, First Amendment, this has to do with symbolic speech. Okay, and the court, you have a right to express yourself. And with constitutional law, with First Amendment, content-based restrictions, the most important thing to remember, the first important thing is the government cannot prevent or oppress certain types of speech. They can't curb your right to express yourself. You have the right to express yourself, and the government can prohibit it as long as they're not focusing on what it is you're saying. So look behind the purpose behind the law. So if they say you can't burn a document inside of a building, they don't care what type of document you're burning. it's a safety hazard, it's a fire hazard, so that's why. But if they say you can't burn a copy of the IRS code inside of a building, well, you're telling me that a phone book's not flammable, but an IRS code's more flammable? It doesn't make sense. They're trying to suppress certain type of expression, which is exactly what they're doing here. They're saying you can't burn a copy of the US Constitution because we don't want you to, express your views, and that's the whole point of the First Amendment. The government cannot suppress you from expressing your views in a certain way. So therefore, it's going to be unconstitutional under the First Amendment, and the statute should be struck down. Okay, that will do it. That is a wrap for question 4 from the 2007 July bar. It's mostly criminal law, slices constitutional law, and there you go. Hopefully you enjoyed that.